Hi, everyone. Hi.
Hello.
We are at the main office filming today. And you know why? Because the wind is blowing too hard at our other office. So somehow the internet is down. It's crazy that our life depends on the wind. Internet's slow, can't file cases, can't print. Like, I can't believe we're still living this day and age that our work life depends on the wind. But Marty's at the main office. This is where I normally sit. And Galen's having a great time because he has extra big room to set up. And yeah, it doesn't look bad. Pretty good. Welcome to today's live. We are going to focus on one story, and we're going to focus on a success story. The main news that we're talking about today. I forgot to introduce, by the way.
Hi, I'm Margaret.
She'll be joining and we'll be asking a lot of questions. If you guys ask any questions, she'll read it to me. She'll be answering a lot as well. She's also one of the account managers here. And so today we are focusing the first story on that it's getting harder to get loans unless you're a U.S. citizen. We're going to talk about that. It's pretty crazy. The second story is about a 212 waiver. It's this Canadian national that came into the U.S. and her visa waiver got denied, wasn't allowed entry, even though her child was here in desperate need of her, and she was banned to come to the U.S. for 5 years. It was devastating. We filed the waiver. It took a year, got approved, and now she's able to come back as a tourist. It's a fun story. It's very heartbreaking. It's a lot of work. It's a lot of uncertainty, but it's a nice completion. And so we're going to talk about those two things. And again, as we're going through the success story, as we're going through the news, feel free to let us know your questions, and we're happy to help answer as much as we can. Yeah, good. Ready to get started? All right. The first news is about SBA canceling loans for green card holders. That's the main story, right? And if you guys don't know, getting a loan from SBA, the Small Business Administration, is one of the best ways to get loans for a business. By far, the best way to get a loan is through a mortgage. That's typically what 99% of people get their best mortgage. There's one step better. That's for really, really wealthy people. They use collateral for their stocks. They get a little better interest rate. But if you're not very wealthy and you don't have collateral, then when you purchase a house, you get a really good mortgage. Next to that, the next best mortgage, the loan, whether it's by amount that you can get, whether it's by how low the interest rate is, and by how long the term is, the next best thing is the SBA loan, by far, not even comparable. Everybody else is like twice as worse, 3 times as worse, right? If you're a traditional, I mean, we see loans that are like 25%, and it's like you have to repay in 1 year. That's quite bad. And like you're limited to like a couple thousand. Like that doesn't help any small business to really start up, to run a company. For years, not years, for decades, people who have green cards starting their business to continue their business have relied on the SBA loan, the 7A, the 504 to get a loan to run their business. But as of March 1st, 2025, or 2026, that is now stopped. That canceled. Green card holders can no longer get it. Is it good? Is it bad? Let's talk about that, right? What do you think about it?
Yeah, so when you say green card holders can get it, like what if it's a couple and the wife is a U.S. citizen and the husband is a green card holder and they both own the business? Does that mean that they don't qualify anymore?
Yeah, so if they both own the businesses and they both are on the tax return, they're both part on the ledger, the SBA and the bank will probably not allow it. If it's just the U.S. citizen who is the 100% shareholder, and the wife is just, the wife or spouse, or maybe the wife is the U.S. citizen, husband, and they have community property, that's fine. But as long as the business tax return shows who is the owner, this individual, this name, okay, is this person a U.S. citizen? You provide the naturalization certificate, provide the passport, then it goes through their compliance. So yeah, if they're married, that's fine. But one easy way around that is that for the green card holder just to drop off, like if they own an LLC together, well, just transfer all the ownership to the U.S. citizen, and that's relatively easy to do. But for most people, right, people who work really hard to get a visa to come into the country, they work really hard to convert that visa into a green card. And then they still need to wait 5 years, sometimes 6, sometimes even longer before they can convert their green card to become a citizen. Well, now during that 5-year, 6-year process before you become a citizen, you cannot get an SBA loan anymore. And this wasn't the case just 2 years ago, right? For the longest time. As long as you are a green card holder and you own more than 51% of the business, you can get a loan. And that has helped so many people, whether they're doing the investment program, the EB-5 program, whether they're doing, an L1A, EB-1C. There's so many ways, not L1A, sorry, for people who are doing EB-1Cs. They have a company set up. They work their butt off to get the green card through building up a company, hire 10 employees, or more, and then they get the SBA loan. Now that option stopped. And prior to 2024, you can get the loan if you own 51%. And then now it's, only U.S. citizens can apply.
Do you think this will lead to more green card holders applying for citizenship?
That's what we've been talking about the whole time, right? Like, as a green card holder, your rights are just being stripped away from you left and right. Like everybody is being downgraded, right? If you're a green card holder, it's almost like you're just a visa holder now. And if you're a visa holder, it's almost like you're undocumented in some ways, And so I think if people were thinking or they were on the fence of whether or not to become a citizen, like they already been a green card holder for 4 or 5 years, 6 years, maybe they've been green card holder for 10 years, but they never felt like the need to apply for citizenship because they didn't feel like, they needed to, but they relied on, the SBA loan for the past and they want a new one. This kind of forces them to do it, right? And in the future, we've seen this in the past, past 10 years, like you couldn't get a certain medical benefit if you were just a green card holder. You couldn't get a retirement plan if you were a green card holder. What if one day Social Security runs out and says, sorry, if you're just a green card holder, even though you paid into the system, you can't get it anymore, right? Like they could tweak that. And so now you can't get SBA loans anymore if you're just a green card holder. So the rules are changing. And this happened within 6 months and a 6 months period from 2024, the end of 2024, 2025, and now, officially in 2026, boom. We can't. And that's SBA loan, right? What if we talk about mortgages? What if we talk about you're not able to buy property? You can't, you're just a green card holder. We won't allow you to buy property in the U.S. Well, right? It hasn't happened yet, but we've seen some legislation in Texas say if you're part of a particular nationality, you cannot own property, right? And so we're seeing the rights and privileges of green card holders getting stripped away.
Why do you personally think that this is happening?
I think funds are just running low in the U.S. I don't know. It must have been thought out, right? These are not just willy-nilly, somebody just thinks of it. This might be a good idea. This takes so much paperwork and so much bureaucracy, especially through the federal government, to make these drastic changes, right? And it wasn't the real ID. That took 10, 15 years to implement, right? To have your driver license convert to a real ID so you can fly. It took 10, 15 years to prepare and then to announce and then for people to know, and then there's a whole campaign. This, decision, green card holders, you can't get SBA loan. They happen within months. So I've never seen the federal government move that fast. So there's definitely a strong urgency by this administration and this government. Arguably even before this government, right? Because it has happened in 2024, right? To start pushing for the change. There's a strong urgency to kind of strip away rights of green card holders. And that's kind of concerning for a lot of people who are just even visa holders, because it's wow, I worked so hard just to get a green card that maybe I can't travel, maybe I can't get loan, maybe I can't, what's the point of this green card, Mm-hmm. So it's a crazy time.
Okay, so one of the first questions is I-751 pending for 2.8 years based on domestic violence. Currently divorced, what should I do?
751 waiver, right?
I'm assuming.
Yeah. 751 waiver, domestic violence, divorce. keep on preparing your case, do a really good job. You're probably gonna have an interview, really win at that interview. How can you improve the chance of your case being successful? Well, one is focus on the case itself, right? The core arguments, right? And you might have already submitted a lot, but you have more time to prepare for it, right? Because, just think of it like a test. You already, submitted your test. Now it's the teacher's going to grade it, but it's not over until it's over. So you have a chance, years from now, potentially, before you go to an interview. And that's the real test. So keep on preparing for it, right? And the second thing is just make yourself a really valuable individual to the United States. I don't know how many cases I've seen get approved that are really weak, purely based almost on the resume of the individual, right? Like, you could go through our YouTube channel, 751 Waiver, and all these other cases where it's like, how did this case get approved? Been unlawful here for like 15 years and then filing a super late 751. Well, they worked for a long time. The officer sees them, likes them. It's like, okay, contributing to the U.S. economy, no other criminal record, approved, right? And so that's something that's not in the case law, but because it's discretionary, you could use your resume and who you are as an individual to appeal to the heart and kindness and discretion of that officer. That's my advice. What do you think?
Yeah, I think for I-751 waivers, especially when they're based on abuse, it is taking about closer to 3 to 4 years. So it sounds like her case is processing normally, but like Joseph said, preparing. If she doesn't get an an interview, she can get an RFE. So just preparing, what are some additional documents that you can provide just in case you're questioned? Are there any more letters? I know sometimes a lot of clients feel like there's nothing else I can give, but you really just have to think through everything.
I mean, so many clients say, I don't have anything to give. We sit down, we talk for 5 minutes, and we come up with 50 things.
Yeah.
And then they get the 50 things, and then they say, wow, I'm completely out. And then we talk for another 15 minutes, and we got another 50 things, And hopefully watch some of the videos, and you can see what other clients have submitted. Use ChatGPT, throw in your situation, and maybe don't do ChatGPT because that's public, and then the officers are using ChatGPT so maybe that's not a good idea. But just ask for general ideas, right? Like, what additional evidence and brainstorm a lot. And there's no limit, right? It's like an open book test. So there's no limit to how much you can provide and prepare.
Uh-huh. Okay, next question is, can I marry someone who has an order of deportation? Would that help his case?
You can marry them, right? Nothing is going to ever stop you from marrying somebody. Now, after you get married, I'm assuming you're a U.S. citizen. Your question becomes, does this bring an equity to this case so that it helps him with his immigration case? And there's a couple different ways, right? One way is potentially, now that this marriage is real and actualized, can you get a bond? Can they come out? Do they not have to be detained anymore? Is there a way to close the case? Is there a way to file an extension? Is there a way to now convert the deportation case into another type of case? That becomes much more discretionary on the immigration judge. Now, if after deported, can you then petition them and have them come back to the U.S. with a waiver, right? Getting married is the first step. Then you qualify for all these other things. But whether or not those things succeed is still a huge question mark. So my advice, don't get married thinking that it will definitely just somehow get the green card immediately and it's a guarantee. It is not. We've seen people go through the process, or people are in the process right now. It is not a guarantee. So if your marriage is purely transactional, where it's like you just want to get the green card and that's it, it's marry for the love, for the relationship. And if they get deported, so be it. And you guys have another plan for your family that you guys can somehow come back or move abroad, right? Will it help? It won't harm it, right? So it is an equity that you can argue, but it's definitely not a guarantee.
Okay, and then someone is asking, I have a pending I-751, almost 4 years with no conditional, with conditional green card. Can I apply for N400?
Yes, you can. So apply for N400. The two of you go to the interview together, because multiple things can happen. you might get a double interview, which is so fun. You do the 751 interview and you do it N400 at the same time and both get approved. Don't expect that. USCIS is a mess right now because they're so busy with everything. So if you don't get that, doesn't mean your case is bad. If you get that, doesn't mean your case is good. It's just, that officer that day, can they process it, right? So you might get the N400 first, and then you might be called in for another interview to the 751 interview. You might do the 751 interview first, and then do the N400 interview. But the N400 application just basically pushes the case along. So definitely you can file. It will definitely push things, and prepare for both.
Okay, this one is there new cases that were able to change status from B1, B2 to J1 being from a banned country?
We haven't done any. And it depends on which banned country you're from. But if you're part of the 75 country that have been banned, so you can't get immigrant visas, your B1, B2 is still valid, and B1, B2 changing to J1 is totally able. It's not part of the ban. However, last year USCIS also came out with a rule where now all B1, B2 change of statuses are all discretionary as well. So even if you meet all the hard requirements, they could still deny you. So you want to do a really good job doing it. There's nothing explicitly saying you can't. So do your best.
Okay, and Grace is asking, my ex-husband filed an I-130 only and doesn't want to withdraw. What will happen if I send USCIS a letter?
Husband file I-130 for you, doesn't want to withdraw the I-130, and then what? What letter? Why does she want to send a letter?
Yeah, I'm not sure.
Or the husband wants to withdraw?
It says doesn't want to withdraw.
Oh, maybe she got divorced and married somebody else, right?
Yeah, because it says ex-husband. So
oh, ex-husband. Yep, got it. Yeah, you can send a letter. Doesn't matter. It's fine.
Yeah, basically just updating them.
Yeah.
Let's see some of the same questions. So what about habeas corpus for someone who is in detention with denied cancellation of removal?
That might be the only chance. So do it, right? It's difficult, but we have seen so much success all across the U.S. All the immigration lawyers who are doing removal defense talk about it. We're going to launch a nonprofit. Well, we already launched nonprofit. We're going to do a nonprofit event sometime later this year, and we're going to try to provide a lot of habeas corpus training and provide that to people who might need it, use it in the back pocket. But if they're already detained and everything has already been denied, that might be your last option. So look into that. Nobody knew it was going to work, but thousands of cases have been filed, and a lot of them are successful. And so even if you have a weak case, just do it.
Okay, and I just got married. How long after marriage do I wait to request his card for him? Which I'm assuming his petition, to file.
Right. That depends on a lot of different things. When did the other person come into the country? What status are they in? But legally, right, you can file the 485 and the I-130 for them. If you're a U.S. citizen and they enter the country, with a visa, they overstayed, they didn't overstay, technically you can file it the day after you got married. But if you file it within a short window of they coming in, did you lie to the custom officer? That might trigger some sort of audit, right? If you have other things that you didn't clean up, right? Criminal records, you might want to clean that up before you file, or else that's an inadmissibility. So just, technically, yes, after you get married, you can immediately file the next day, but you want to make sure you still qualify for everything that's related to the 45 application.
Yeah, and you also have to submit Bonafide marriage documents. So if you don't really have that, then you might want to wait a few months.
Right.
Yeah.
But some people are super urgent. They have to file before the I-94 expires, and it's scary time right now. And so some people just file. And so if people are on a, time crunch, we say just gather 15 of the best documents, even if it's just like 7 documents of just a lot of pictures, a couple bank documents, and then a couple affidavits from friends and family. Just get 15 and then file, right? You don't get 50, just get some.
Yeah, even then, it takes sometimes like our best clients 2 months to even prepare, just because of all of the things that they have to do. So
That's true. It's so much. It is so much.
okay, and then someone from YouTube is asking, for L1A, does a sole proprietor firm qualify? IANs for LTD firm, minimum for how long the firm should have been in business to satisfy the L1A requirement.
Great question. We haven't done a sole proprietor L1, but I know it worked before. So it's really interesting. I was studying the L1A, and I was really surprised that could work. But we haven't done it. Now, what was the question?
So does a sole proprietor firm qualify? Minimum for how long the firm should have been in business to satisfy.
The minimum time is the same as all the other L1s, right? So if it's a startup, it's a startup. If it's overseas, well, you need to have been employed as an executive for over a year overseas. So all that is the same, not different for a sole proprietor. But the thing about sole proprietor is just so much harder to prove. Like, we have such a hard time doing L1s when it's even a C corp, an LLC with employees, with lease agreements, with so many things, and they still challenge it, right? So I think theoretically sole proprietor could work. It's just so much harder. But if that's all you have, then go for it.
Okay, someone is asking, how long do you think the 75 countries pause will last? Which
I've been saying this, and I will continue to say this until I'm proven wrong, right? I think it will last this entire administration. So I think it will go on for another 3 years, and I think it will expand. So more countries might be added. The 75 country ban from immigrant might extend into non-immigrant. USCIS will implement the same rules. Maybe not for a 75 country, but just across the board for all countries. That's my prediction. That's where I see the trend is going. That's where I see this administration, the parties, even today's news talking about, green card holders cannot get loans. I mean, we're not even talking about people getting visas to come to the U.S. We're talking about people who are green card holders can't get loans, right? So green card holders, their rights are being stripped away, let alone people who haven't even applied for adjustment of status yet, right?
Okay, and then another question from YouTube. Should someone file an I-90 renewal by themselves, or should they get a lawyer?
If you have a problematic case, definitely do a consultation first. Problematic as in you've left the U.S. for over a year, sometime in the past 5 years or longer, because that could be challenged. So then the purpose of the consultation is really just to be informed, like, oh, other clients have filed this and got a request for evidence, have been denied. What should I prepare for? So you're like forewarned, right? Don't you file I-90 and suddenly you get annoyed, or notice of intent to revoke or request for evidence. That'll be terrible, right? And so at least you can start preparing, and then when the time comes, file. And if you don't need it and it just gets approved, then great, right? So at least do a consultation if you're in that situation, or if you have a criminal record, right? So you got the green card, nothing happened, but in the past, you got 1, 2, 3 misdemeanors, you got a felony charge. Well, now this I-90 is going to be a very difficult renewal, right? So at least do a consultation, kind of review that. But if everything is clean and squeaky and, good, I-90 is not the hardest application.
Okay, and then have DACA with illegal entry, wife is a citizen. Should I go for AP advanced parole first, then file with my wife?
Yes, you should. You should definitely do advanced parole. You cannot file before you do an advanced parole, so definitely don't do that. And definitely don't leave the country without advanced parole. And if your advanced parole expired, don't leave the country. And so definitely look at the advanced parole. We've seen the family all file for advanced parole, and then they get different dates, but only they assumed it was all the same, and so they left. And then the people with valid advanced paroles were able to come back. People with expired advanced paroles got stuck overseas. So all of that. But if your advanced parole is valid, you leave the country, do the thing that you applied for advanced parole for, visit the family, do the emergency humanitarian thing, do the schooling, or whatever, however you apply for advanced parole, fulfill the promise, and then be able to show it to the customs officer, because they hate it when people apply for advanced parole, go down to the border, and same day, second day, turn around. That's like, you clearly are lying and trying to game the system.
Okay. Another question, is there any ICE detention risk for people going in person to get an I-551 stamp for an expired green card, waiting for the removal of conditions?
I haven't seen any, and I haven't heard any. So I think the risk is relatively low.
Okay. How likely is it for judges to do bonds for someone being held?
If it's a mandatory bond, if it's a mandatory detention, there's almost like no chance. If you file the habeas corpus and you have a strong argument that the government, abused their rights, maybe the immigration judge will be able to grant the bond or drop the case. That's why it's so important to do the habeas corpus arguments, even up front. But yeah, I think ICE is not approving bonds to the best of my knowledge, right? I don't see them doing it. So it's all up to immigration judges now. And then they're supposed to just push everything to immigration and oppose everything. So even if they want to give it to you, it's just their internal policy to kind of oppose everything. And so now immigration judges are being more so on the good side because they see bad cases in front of them, right? In the past, a lot of ICE agents would just approve the bond by themselves. So only bad cases show up before immigration judges. But now, a judge opens up his calendar. He goes in and he has to do 25 hearings that day. They look through it, 10 of them are terrible. So just quickly, okay, approve the bond, close the case, right?
And then someone is asking, I-140 is approved but already out of status. Could I apply for I-601 waiver, and how long is processing?
Come again?
So I-140 approved, but already out of status. Could I apply for I-601 waiver, and how long is processing?
We're seeing processing time around 3 years, right? And obviously, you should know I-140 approval, the 601 waiver has to be on an immediate relative, U.S. citizen or green card holder, right? So it's not based on the I-140. I-140 just kind of gets you through the door, but you still need to prove that the hardship. Now, maybe because your parents, F4 may be too long, so this is faster. That's good. But if you're married to a U.S. citizen, it's almost like, why are you doing I-140? But yeah, so I-140 approved, great. Go through the process, but you still have to prepare for the waiver, and then it might take 3 years. And then once that gets approved, then consulate.
And then someone is asking, is a lease mandatory for a bonafide marriage if living with family and not paying rent?
That's a great question.
I know I'll chime in, but we haven't always used official lease agreements. Sometimes we prepare what's called a landlord letter. And even if you're not paying rent, usually your tenant or your family member can sign off on it and get it notarized. And that's worked for us, at least.
I would say, if you don't have the lease, get 3-4 other super strong documents to prove that you do definitely live there together, right? So back in the day, I remember it's like, okay, one person has J. Crew magazine with their name subscription, sending it to their house. Another person has H&M, their name, the address at their house, and it's like side by side, right? Or you have mail, and there's everybody, it's all mailed to the same address. So it's like there's all this proof to show that you guys are living there. You're not both paying the rent, you're not on the lease, it's family, but pictures of the rooms, pictures of the hallways, nobody's gonna set up an entire room that looks somewhat messy just for this, because the officer can go into the house and check, and if it's not there anymore, then you have a vacant room the entire time. Then that's kind of nobody really does that. So yeah, lease is not mandatory. Very, very few things in immigration is mandatory. Something even like birth certificate, where it says it's mandatory, but if you really look closely, it's like, oh, well, some people can't get a birth certificate, so they do use secondary evidence, right? So yeah, just if you don't have one thing, try to get 3 or 4 things that's stronger to prove it.
Okay, another question is, my I-130 was approved and I-485 is still pending. How long will it take to complete?
Yeah, if you're married to a U.S. citizen, in that situation, we typically see 9 months, right, total. But some cases are 3 months, 4 months. Yeah.
And And let's see. Can my wife keep a U.S. job if we move to Brazil?
Absolutely.
Okay, another question. During a divorce process, is it the right time to start a bonafide marriage? Prof. Address set. I don't know if I understand the question.
During a divorce process, is it the right time to start a bona fide marriage? I have no idea. A lot of people start 751 waiver processes during the divorce. So that's the right timing to do it.
I think it's the one that's getting a divorce from someone else, starting a new relationship.
But it says prof address set. So
Oh,
yeah.
Yeah, it's kind of hard to tell. Okay, so DACA holder with legal entry, brother will be citizen. How soon can they help with change of status?
Technically, it's adjustment of status, right? And what you want to do is, I mean, if your brother is a U.S. citizen, they could just file the I-130 for you. It will take forever, right? But you still need an advance parole before. Oh no, you have legal entry, right? Oh yeah,
Yeah,
So
legal
if you have legal entry, then when the I-130 gets approved, the priority becomes current. Then you can try to file for maybe the National Visa Center. Get the waiver, go abroad. It's still much better if you got married to a U.S. citizen. Then it's much more immediate, right? So having a brother or sister who's U.S. citizen petitioning for you is still a significant long time for most people.
There's a Spanish question, but I'll help translate. And they're asking if someone has a pending interview in Mexico, but they recently got a traffic ticket, will this affect them?
What do you think?
I don't believe if it's, like a minor traffic incident, that it will affect. Gabby, can you talk for him?
just make sure that everything is settled with the court. Pay the ticket and don't avoid going to court or avoid a warrant or failure to appear, and it should be.
Right, can you repeat that just to make sure?
Yeah. So basically, it will not affect you as long as you paid the ticket and you did everything that you had to do, whether it was going to court or take any courses. And it'd be good just to have some documents to show that as well.
Yeah, and some traffic tickets are really bad. Like it was a misdemeanor, right? Like you were speeding like 90 miles per hour, and then it's a traffic ticket. It's if it's just like you parked in the wrong lane, right, or parked in the wrong spot, those are pretty small. But we have seen these snowball, right? You didn't show up to the court, you didn't pay the fine, you didn't even know about it, and it converts into a warrant, and that becomes a bar. So definitely don't do that. Today's success story is about a 212 waiver. And what I'm talking about is this Canadian mother came into the US and the customs officer stopped her, put her in secondary, canceled the visa waiver, and issued her an expedite removal. 5 years, you cannot enter the US. The mother was devastated because her daughter was on medical treatment in the US. She needed to come to see her daughter. Tried to apply for another B1, B2 visa, got canceled. Tried to apply for E2 visa, got canceled. So many things to try to reverse that one custom officer decision. Didn't work. This happened in 2023. And so after trying everything, couldn't help it, finally filed the waiver. It was a very difficult waiver to file because she's been in the US for so long in the past. She never violated her status, but because of her travel records, the custom officer determined she violated her visa waiver, even though she never worked, right? But because she was just so frequent in the U.S. taking care of her daughter, the customs officer, CBP officer, just canceled the visa, removed her. She wanted her husband, her whole family wanted to fight against that CBP officer, sue the CBP officer, because it's just one CBP officer's decision, but because the case was just so weak, it wasn't really worth doing. So we filed the waiver. The 212 waiver in 2025. It took one full entire year. It was just approved like 2-3 weeks ago. Grace and her team worked really, really hard on it. We're very happy. It was a long shot. More normally, we attach 212 waivers to really strong arguments, but in this case, you're applying for this big grand waiver just so she could get a tourist visa to come in. It seemed like it was really weak, but it worked, and now she can finally be reunited with her family. I love this story. We want to share every single detail of it. I mean, but while protecting client privilege, so we can't share identifiable information. But I want to walk you through the process, the decision, because it's a matter of faith. The client was in a situation, was desperate, and we tried the different options, A, B, and C, and applying for this waiver was a long shot, but it succeeded. And in her reply email back to us, she even said "Is this real? Is this possible? Cannot believe it," because the chance of success was so low. But it worked. So anybody who's going through that 212 process, or who might have to, right? Let's use this as as a comparison. That's the benefit of these kind of videos, right? So let's get started. Oh, that was actually just the intro.
I guess for anyone who doesn't know what the I-212 waiver is, can you help explain a little bit about what it does, what it's for, when it's used?
A 212 waiver is when somebody is applying for a non-immigrant visa. So think tourist visa, think H-1B visa, think L-1 visa, think anything that's non-immigrant visa. You don't get a green card. You just are able to get a work permit. You just get able to come into the U.S. to visit, to stay. And you have been denied for some reason. The consular officer, the customs officer, somebody denied you for some reason, and now you are ineligible to come into the U.S. Now, if you got denied without prejudice, maybe you missed the paperwork, you missed the signature, you don't have to apply for a 212 waiver. You just reapply for that visa again, right? So we see that with TN visas all the time. Right? You go to the border, you're applying for a TN visa as a Canadian, and they're like, "I want to see your original diploma." Yeah, okay, you got denied, but you don't have to apply for a waiver. Just go home, pick it up, and come back, right? And then and that's totally happened before. But in this case, and for many cases, maybe somebody was traveling on their visa waiver too often, too much, stayed too long. Custom officer just don't like you, don't like your background, cancels your visa waiver privilege, cancel your ESTA. Now you have a 212. Now you cannot come back in. And that's not to say every customs officer denies people and expedite removes them. A lot of times customs officers say, "You know what? I'll give you a warning. I'll let you come in for 1 week, but next time you really cannot do this again." And that's okay. Or sometimes customs officers says, "You know what? I can't let you in this time. Go home. You get your return ticket, get all the other stuff ready, then come back." But this time, for this client, this Canadian mother, this customs officer was pretty strict. Without any warning, locked her up, grilled her back in 2023. It's not even, we're not even talking about 2025, 2026, right? We're talking about 2023. This customs officer says, "You've been in the U.S. for too long." And she was legal the entire time. During COVID, it was a little bit long. She had to file an extension. Everything was legal. She did everything right, but the customs officer just didn't believe her. So heavy-handed, denied her entry, barred her from coming to the U.S. for 5 years. This was a devastating blow for the family, because the daughter was here, was on medical treatment. It was, she really needed to come. And because of this whole ordeal, she ended up having to pull the daughter from the U.S., the medical treatments, go back to Canada. It was pretty heartbreaking for the family. They had to make a lot of adjustments. But ultimately, they decided, well, I might still want to go back to the U.S. I don't want to wait that 5 years. Let's file the waiver. So that's why you needed to file a waiver.
Okay. Yeah, and I think it saved her 2 years, right? Because she still had to wait another. If this were to be denied, she had to wait an additional 2 years.
Right. So from 2020 to 2023, 5-year ban. So she could try to reapply for any visa in 2028, but there's no guarantee, right? You don't have to file a waiver at that time, but at 2028, it becomes you're just like another normal person. I'm not going to use this to penalize you, but I still have to believe you qualify for everything, right? So by doing this, in January 2026, we pulled it back by 2 years, and we have a much stronger and much more confident application for a tourist visa. So let's talk about the waiver now. Grace and her team prepared it. I looked through it. It's 10 pages, single space with tiny little margins because we didn't want to make it too long. 10 pages is already pretty long, super small font. If it was normal font with normal margins, I think it's 14 to 16 pages. The reason I want to talk about that more and more is because there's so much talk between two camps of attorneys. People who say you want to file with big, thick briefs, and people who say you want to file with short briefs. You know what? Both are wrong. You know, you can't, law and argument and persuasion is not as simple as the longer the better or the shorter the better. It depends on the situation, it depends on the facts, right? Like some cases I've tried to make it down to 2 pages, you know, and I enforce that. Sometimes we file with 80 pages, right? And so depending on the situation, you need to tweak your plan accordingly. So in this case, I think it's important to share, okay, this situation, we did, you know, 10 pages, but super small, but so normally it's about 14 pages. And we wanted to cover a lot of topics. That's why we had to go through all these things, right? But having read through it, what do you think of it?
Yeah, I mean, I think what's hard with waivers in general is that they're discretionary. So like you said, you never know like what's enough. And in this case, there was so many things that we had to touch upon. So we talked about her good moral character. We talked about all of her lawful stay. We talked about her lack of criminal record. We talked about her family ties and pretty much, like Joseph said, her daughter's medical needs and why she needed to be in the U.S. And it was just a lot of different variables that Grace's team had to navigate because they had to show non-immigrant intent, but then they also had to show that she had ties to the U.S. So I think there was definitely a lot of strategy that went behind it.
Right. There was so much work and so many applications that happened before this, right? So between the CBP denial in 2023, the customs denying them, and then there was you know, filing an E2 and filing another B1, and all those got denied, and then filing this 212. And we don't know if this is going to be approved, but we already spent all this, and that's part of the record now. We have to explain all that away. So it's not a simple, here, let's just do a 4-page 212 brief with like half of it is law and say, you know, the United States is better than this, we should approve it. We can't do that, right? I mean, I've seen some briefs like that in the past where it's like, okay, well, then we'll, you know. But I think it's important that there were a lot of facts, that it was very nuanced, and and this was her last chance to really secure a win. Or else she might give up and never come back to the U.S. again, right? So, so again, the first part, and again, for 212, I think what most people may know or may not know is you're comparing why you got denied and why it's important for you to come to the U.S. The benefit of the United States consulate approving you right now in 2026. Here's somebody who seemingly have abused their visa privilege or visa waiver privilege for that matter, and have abused it for years. Why should we waive them and allow them in now in 2026 when the consulates are all super strict, right? Yeah. So what's the benefit to the U.S. and what wrong did you commit? And we had to do a big balancing act. In this case, we spent close to 2 full pages talking about the wrong that she committed. We don't usually do that. And the reason we spend so much time doing that is because the crime she committed was so insignificantly small, right? She had no unlawful presence. She was a visa waiver. She was a Canadian. The wrong she committed was a purely discretionary interpretation by this customs officer that in the past 6 years, from 2020, you know, from 2014, 15, all the way to 2023, that entire time that she was a Canadian coming to the U.S., that she stayed a little bit too long. But she never unlawfully stayed. She never worked. She has a great resume, a great background, a lot of things in supporting her. Her wrong was just an inaccurate interpretation of the law. She didn't know. And it's not like people get a formal orientation by the U.S. government. Once you get a Canadian and you get a visa waiver, you sit down, you watch a video explaining what you can or cannot do, right? So it's an honest mistake that a lot of people do. And maybe a warning would have sufficed, but this officer was a little bit heavy-handed. So we wanted to thoroughly explain that. Now, if she committed a much more severe crime, maybe it would have been much shorter and said, she committed this, we understand, this is the facts. Now we go into talking about how important she is to the U.S., right? So 2 solid pages explaining that situation. But the case is complicated, so we have to talk about the good moral character of this person. Like, this person is not a threat to the U.S. In the past, we might not have done that, but in this case, we definitely did because of this administration, right? She's not a criminal. She's not one of the people who's coming in, eating dogs, you know, unlawfully working and stealing American jobs. She's actually contributing to the U.S. and all this stuff. So we want to talk about that. And one reason why we talk about that also is because she's just trying to get a B1, B2 visa. It's not that strong of an argument. Like, we couldn't argue like, oh, she's going to come in and build up this big enterprise, right? I mean, we wish she chose that, right? I mean, it was such a big, long conversation in 2025 before we filed this case. Like, it would be such a stronger 212 application if we were arguing for the E2. Like, she needed to be granted this so she could come in to do her E2 business, right? That would have been much better. That's what we advise all our clients. But because of the situation, she already pulled her daughter out. She's not going to run her E2 business anymore. She changed plans. I mean, this whole process is taking years. If it was a matter of like weeks or months, maybe she would have said, okay, I'll keep the E2 business. She's not going to continually fund a business in the U.S. Her family's not there. She's not there. There's no chance of getting approved, or the chance of approval is so low. So had to cancel the E2. So the only thing we're stuck with was the B1, B2. Hard argument. So that's why we focus a little bit more on the good moral character part. And then because it's a B1, B2, we were forced to talk about her home ties back in the U.S. and why she needed to come to the U.S. So, you know, a simple 212 application became like so complex, you know, it was hard. How does it compare to the waivers you do, right? I mean, you do, I don't know, you've done like 50 plus waivers, right?
Yeah, I mean, in a lot of ways, it was very similar. Again, arguing her ties to the U.S., the good moral character, the consequences of a denial to her family. So it was really trying to appeal to the officers, more like human.
Yeah.
And so, yeah, very similar with all of those arguments, supporting documents. I think there was about 20 exhibits.
Yeah.
So not only saying these things, but providing supporting evidence.
Yeah.
And yeah, that was discretionary. So
Yeah.
hoping for the best.
Yeah. And it's so crazy that we got that approval here in 2025, right? So, I mean, so many people, when they think about immigration, they think about just such big picture, like, oh, life was so much easier back in 2020, you know, pre-2025, right? And they say Trump era is so hard. Well, this case got denied in 2023. And then now this case, the waiver got approved in 2026. And how do you interpret that? This was a really weak case. The client had no confidence, but just needed to try. His last-ditch effort. What do? We didn't know if it will succeed or not. We could only do our best. And that's why I love my job, because instead of just speculating, we just try and we see the result. And props to Grace's team. Props to the client, and I really wish the family the best. And for anybody who's going through this process, just kind of know, right? You never know until you know, right? You don't know until you know. And until you know, you just try your best. And what else can you do, right? Don't give up. Thank you guys for watching. Take care. Bye-bye.